So hello, good afternoon, and welcome to the King's Public Law Conference of 2021. I'm Sam Kareem, and I'll be chairing this event this afternoon for an hour and a half of really a tour de force of all the things that's going on in the world of administrative law and judicial review. And I welcome you from what is in normal circumstances, a very untidy room, but a tidy room in my chambers today here at King's. We've got a wonderful panel of speakers for you today, in particular two keynote speakers who I'll introduce shortly. But in the latter part of this afternoon is our breakout sessions, which will occur at around 3 o'clock. That has a different Zoom link. Ordinarily, we would just usher you to another room in the building or in the conference suite, but there's another link for that, and then you can choose your individual breakout sessions subject to where you want to be. If you want to be at planning, social or healthcare, regulatory or commercial and procurement updates, the link will be provided for in the chat function, just in case you haven't received it by email. So certainly in my view, since 1997, or perhaps a bit slightly before, judicial review has been really subject to a lot of political concentration. And that's probably more so now than ever. And most of you will be aware of the Judicial Review and Courts Bill, which I think is at its second reading stage, which slightly tinkers with the ability of the court's discretion to make quashing orders, for instance, in particular, allowing a public body to first remedy the defect before a court makes an order, and sometimes allows for limited retrospective effects, namely that things can be done before all the things that are done before a quashing order are made. Not all of it has to be deemed unlawful. But I think most significantly of all is the removal of JRs of upper tribunal decisions and some procedural amendments, which I think is largely welcomed by most people. But for our first afternoon session, I'd like to welcome our first speaker, Mr. Justice Julian Knowles. Mr. Justice Knowles was appointed to the High Court, and specifically the Queen's Bench Division, in 2017. He is our liaison judge for the Administrative Court in the Northern and Northeastern Circuit. He was called in 1994 and took silk in 2011, and as a practitioner was a specialist in criminal law, extradition, human rights, public law and media law, a proper administrative law specialist, as I put it. He was involved in many significant cases during his practice, including the Pinochet extradition case. I'm very delighted to welcome Sir Julian this afternoon to speak to us all, and I would ask him to, if possible, speak to us today about how virtual hearings have impacted the work of the administrative court. So without delay, I'll hand over first of all to Sir Julian.
Well, thank you, Sam, for that very kind introduction. I'm a Manchester boy, born and bred in Wythenshawe, so it's lovely to be speaking to you all this afternoon. The last 18 months have probably been unprecedented in all our lives in terms of how we work, how we live. And I think its impact going forward, so far as we are all concerned in the administrative court, will be very significant. And what I want to spend my few minutes this afternoon doing is giving you some hints, tips from my side of the bench as to how it's affected how we do our jobs and therefore how you do your jobs. The major thing that I've experienced since March of last year, obviously when the first lockdown happened, is electronic working and paper working as opposed to electronic working. And obviously we moved to electronic working. I think what you as practitioners need to know is that electronic working is, I've found it much harder than paper bundles, not particularly because I'm a Luddite, but I did always used to enjoy scribbling things in the margins, which obviously one can't do in the electronic format. And it's really vital, and you and your solicitors need to know just how much more difficult it is if you don't comply with the protocols and the practice rules on the filing of electronic bundles. It's really important that things are hyperlinked. It's really important that page limit guidelines are complied with. I've, over the last 18 months, had several cases with thousands and thousands of pages have been filed electronically, and it is very difficult. And I understand, the modern tendency is to file, everything lest you be criticised for not. But really do think, do I need to file this? Is this important? Is this necessary for the judge's decision? And I think, the impetus, the guidance should be to keep things as short and as small as possible. On an average week, I would say I probably get about 5,000 pages to read, which is an enormous amount, and I'm a fairly fast reader. But just so you know, that's our workload in an average week. So the less you can do and the more focused you can be is very helpful, and will help us to focus on your best points. I was guilty of this when I was at the bar. I wrote very, very long scale arguments, 50, 60, 70 pages. And my heart always now sinks as a judge when I get something of that length, because you can lose points and you can miss points. So the other thing, and particularly when things are coming electronically, you should always be aware that, as I say, we do have a lot of things to get through, and really, really try and be concise in terms of what you write. Don't set out lengthy introductions, facts. We've got the facts. We will have read those from the papers. Really do just concern yourself with the points of law that you want to emphasize, because, as I say, we have an enormous amount of material to get through. We're all, pretty attuned to what we need to look for, and so just emphasize what you need. Going forward, I don't know how things are going to pan out. Obviously, we've got new virus variants. We may go back to lockdown. I'm not sure about that. We as judges have been given an instruction that we should be in court, which I think is right, because we need to be in court and the public needs to see us in court. Obviously, there can be amendments to be made. I'm obviously sitting remotely this week, as I said to Sam earlier. But I think, there will be a move back to hearings in court, subject to exceptional circumstances. And I think it is very important that we all understand that justice has to be done in public. And that's the very clear message that we're getting from the Lord Chief Justice and those who set the parameters. We need to be seen in court. We need to hear cases in court. Obviously, remote hearings, people can dial in, but I don't think it's any substitute for actually physically sitting there. And so certainly this week apart, just personal reason, this week apart, I've been going back into court. I've done a trial. I'm due in Manchester in February, I think it is, to do a trial again. And and we all need to, I think, reattune ourselves to go back to the old ways of working pre-March 2020, because I think it's really important, and staff have to go into court. So I don't think there's any reason why judges and lawyers shouldn't. And so moving forward, my best guess, obviously things change on a week by week basis, but my best guess is we will go back to the old ways of working. And I think that that's right, because I think it is very important that justice is done in public. I think that's my 7.5 minutes. Sam, do you want to open the floor?
No, so Julian, yes. What I'll do is, if I can ask you one or two questions, and then and hopefully that'll encapsulate some thoughts that our participants have.
Yes.
I hear that it's right for purposes of open justice and for other reasons why court hearings should be attended, especially administrative court hearings, because of the constitutional basis. But is it right to say that, or what do you think about this, that in terms of administrative court hearings, given that they are so, in very rare circumstances, fact-heavy and mainly submissions-based, they are actually better placed compared to some cases to be done virtually than say, a hearing in Queen's Bench Division where you're actually hearing experts giving oral evidence?
I think that's a good point. My own view and my own sense of, obviously having heard hearings until the beginning of this month or remotely, I just don't think you get the interaction that you do. Sorry, I don't think you get the interaction online that you do virtually. Body language I found is incredibly hard to read online. And obviously, you can see people, but it's just not the same. And certainly I, as a judge, have, do find it really interesting, the almost physical interaction that you get with barristers in court. They know when they've made a good point. They know when they made a bad point. You know when they've made a good point. You know when they've made a bad point. And you just don't get that. Now, I personally, and I can't speak for all my brothers and sisters on the bench, but I certainly do miss that physicality of what do you mean by that? Can you just explain that? Sorry, just show me where you're on the page you are. You just don't get that. And online, you don't get. Online, you can talk over each other quite more easily than you do in court, and I certainly don't find that helpful. You think they've finished speaking, they haven't finished speaking because there's just a delay on the line or whatever there might be. So I personally just find the physicality and the interaction being in court really aids decision making.
One of the second questions I want to ask you was something that you alluded to, which was the bundles and electronic bundles and hyperlinks and so forth.
Yeah.
Do you think we've now moved from physical bundles completely and electronic bundles?
No, I don't think completely. Time will tell. I think inevitably there's going to be, just because everybody's got used to a different way of working. So I don't think completely. I mean, the rules, the people who make the rules will obviously make the rules. If I want to express a personal view, I very, very much prefer physical bundles. In many ways, it's more difficult. Because obviously I can, wherever I've got my laptop, that's my home. But I personally, as I said earlier, like writing things in the margins and scribbling things in notes. I think we're going to go back to probably some sort of hybrid way of working. I think the presumption, and certainly that's, as I say, what we've been told from those above me, the presumption will be hearings in court with everybody physically present. But in the where are we now? The 2nd of December. In the couple of months since term started, we're having barristers appear remotely.
Yeah.
Which obviously means things have to be filed electronically. I think we'll go back to a hybrid system.
Yeah.
My own preference is to everybody being there. Members of the public can walk in. Yeah, they can dial in, on Zoom or Teams or whatever. But I do think justice has to be done in public. And I think most of my colleagues will probably agree.
Thank you, Sir Julian. The final question that's been raised is in relation to user group meetings in Manchester and or Leeds. Is that something that's going to be restarted?
It is, yeah, it will be. In fact, I'm coming to the end of my term as liaison judge for the North and the North East at the end of this month. And I don't know who my successor will be, but yes, that will happen again.
Very grateful. Well, Sir Julian, thank you so much again for coming today and talking to us about the changes and your personal views. It's been really insightful. If we were all in person, I'd ask everyone to applaud, but we shall virtually applaud. And thank you very much again.
Not at all. Thank you, Sam. Nice to see you. Thank you.
Likewise. So our second keynote speaker is Dr. Sarah Nason, and I've asked her to talk to us about the regionalization project, which obviously resulted in regional centres of the administrative court being opened throughout England and Wales. Dr. Nason is well known to me and others in the area of administrative law. She is a senior lecturer of administrative law and jurisprudence at the University of Bangor. Her interests are obviously public law, administrative law, devolution, comparative public law, and legal philosophy. She is a member of the editorial board of the journal Public Law, an executive committee member of Public Law Wales, and a member of the UK Administrative Justice Council academic panel. On a personal level, I know Sarah from many years of probably the beginning of regionalisation. Pre-regionalisation, I remember an event where I attended. I'm not sure if I spoke at it, but she invited me in Cardiff, I think. And this is before regionalisation actually happened, all those many years ago. And post-regionalisation, I know she's been involved in very detailed research into whether or not regionalisation has actually made a difference. So I'm very, very, very pleased that she's here to talk to us about regionalisation and whether, in fact, it has worked. So I shall hand over to Sarah. Thank you, Sarah.
Yeah, so I've, as Sam says, I've been researching regionalisation for some time, and I thought I would talk a little bit about some of the impacts of regionalisation. I'm going back to what was the rationale for regionalisation of the administrative court as well. So I hope that I'm not too academic. I've sort of tried to mix some academic commentary with some statistics. It's interesting. There was a while where there were very few of us who were interested in judicial review and administrative court statistics. And now I think that everybody is interested in these and talking about them. So I think the background to the regionalisation project, it comes in the matter of access to justice. And there were a number of academic studies, particularly Judicial Review in Perspective. And there was a comment from Sir Henry Brooke in the foreword to that, wondering why it was that in this study that was done on judicial review in the 1990s, did only 2% of those cases that were legally aided come from the vast part of the north of England. The Law Commission looked at this in 1994 and felt there was a need to address the access to justice issues raised by the concentration of judicial review in Greater London. And even Sir Geoffrey Bowman's review of the Crown Office list also talked about the need for aggrieved parties to have more local access to justice and talked about the time and cost of everybody having to go to London. And so a judicial working group was convened, and they were looking in particular at this question of the inconvenience and expense that was caused by parties having to travel to London, and the worry that this was prejudicial to people who don't live and work in London and the southeast of England. But I think there had always been a bit of a tension between the importance of access to justice and administrative efficiency. And both of those were rationales for regionalisation, but perhaps in different ways. And Sir Geoffrey Bowman said there would be significant hurdles to establishing local centres. And then this was one of the very early sort of, I only really started my research career at the same time that all this was happening. But tensions on the bench spark admin court reshuffle was reported in The Lawyer. And this was to do with the fact that the main architect of regionalisation, Lord Justice May, considered that there was a need to open regional centres because people needed to be able to access justice. And so this follows on nicely, I think, from what Sir Julian was just discussing, the need to actually be in court. Whereas it was actually Mr. Justice Collins who was raising the other view of saying, well, can we not just have at that point what would have been video hearings, and raising the point that the parties themselves rarely do actually appear in judicial review cases. And he is quoted in a memo to administrative court staff as saying that this would cause a deployment nightmare. And there was a certain amount of background discussion as to whether this was really about the fact that there were a very, very high number of immigration cases in London, and could some administrative savings be made perhaps by having some of the non-immigration local cases heard out on circuit, as it might then have been discussed or referred to. And I put that little picture in there to remind myself that Professor Rick Rawlings referred to this proposal as being judges on wheels, so judges travelling out to the regions. And so this is sort of part of the context, is access to justice or efficiency. But there's also the really important matter of constitutional principle. And Professor Maurice Sunken and I were writing about this in the Modern Law Review, and saying that, in terms of there's effective redress for individual claimants, which is important, but there is also enforcement of general principles of the rule of law. And are we really satisfying access to justice and the rule of law if people are inhibited because of their location from raising these issues? There is an alternative view. It's on a later slide, that actually it doesn't matter who raises this issue of important rule of law principle, that the individual is just a trigger, that's the words of Professor Tom Poole, to get the claim into the system so that it's redressed, but it doesn't matter where they come from. But there's an alternative sort of point of constitutional principle. We were messing around a bit when we put this quote in our journal article, that this is the creation of the county courts, where Abel Smith and Stevens were reported as saying that the majority of barristers wanted the work kept in the distinguished courts. They were concerned about the dilution of recruitment to the bar and hence the calibre of the judiciary. And actually, when regionalisation was proposed, Alba made some similar points to the Judicial Working Group, that access to a High Court judge is part of the rule of law, and the fear that regionalisation would lead to increased use of deputy High Court judges, which it has actually, certainly outside London. And Alba was saying, is there a compelling case of actually having a smaller, more specialist cadre of High Court judges for that reason? This idea of the importance of judicial review being about determining the limits of public power rather than about giving claimants easy access to the system. And it kind of goes back to O'Reilly and Macman and the centralisation. And there was a fear that regionalisation of judicial review might somehow weaken the cadre of High Court judges. And we had a quote in some research from somebody that we'd interviewed saying, would the defendants, the government, central government in particular, would be quite happy about having a cadre of High Court judges being broken up and sent out to the regions. And there was even an argument that a judge hearing a case in a locality with more connection to that locality and more connection to the issues that local people were having might actually be more likely to look into the sort of merits of the case rather than focusing on the legality. And the research evidence shows that's definitely not the case. There is no evidence that judges in the regions are in any way more activist in terms of looking at the merits and then judges from elsewhere. If anything, there is a sense in which they're less so. There's a sense in which they're more cautious. And as well, at the same time as regionalisation was occurring, there was also more the development of the tribunal system, a judicial review going out into the tribunals, and we have to remember that there is a lot more to administrative law adjudication than judicial review. And I think there's a tendency, particularly for academics, to focus on judicial review rather than the whole gamut of administrative law adjudication. I want to put regionalisation in context. I'm glad my slides are moving on now that I'm starting to look at graphs. That it is said that judicial review has expanded exponentially, and even the Independent Review of Administrative Law said that. But the reality is that immigration judicial review has expanded, but all other areas of other civil judicial review have not. And this graph actually shows the number of claims that have actually been granted permission. So it does include both the immigration and asylum and the other civil judicial reviews. But what you see is that actually, if anything, the number of judicial reviews that are actually being granted permission and the number of substantive hearings in the administrative court has been going down quite significantly, and especially in more recent years. So there isn't a growth in judicial review, and regionalisation should be seen, I think, in that context. And again, what we actually see in this slide is that we need to be careful when we talk about success and claimant wins, and the Ministry of Justice itself has got in trouble from the statistics regulator for talking about success as if that is just simply those cases where the claimant is rewarded a substantive remedy. But at least success in that sense, you can see that the number of substantive hearings and the number of claims in which a claimant is being given a remedy is actually reducing in the administrative court rather than increasing, or at least it has been. So that's the context in which regionalisation is set. You will know an awful lot about the practice direction, I'm sure, and the fact that it's intended to facilitate access to justice, enabling cases to be administered and determined at the most appropriate location, and so on. So I won't talk too much about that. The access to justice aims, reducing costs and improving convenience for existing users. So what we find is the General Medical Council in Manchester and other repeat players, local government or large public bodies that are judicially reviewed a lot. It has, I think, improved convenience for them. But the broader notion of if you build it, they will come is a cultural reference I can't use with my students because they don't have any idea what I'm talking about. But the academic argument behind this was if there is a court, the specialist public lawyers will cluster around that court. And what we know is what increases the use of judicial review is comparatively high levels of deprivation, comparatively low levels of performance in public bodies, and access to legal aid funded specialist advice. There is also a sense in which it was argued that regionalisation might create a kind of market for specialist public law services, because we have to remember there is commercial judicial review in the mix as well. There were different regional cases as well. I'm going to focus today on Manchester and Leeds. I have some things on Wales in my slides, but looking at the time, I shall focus on Manchester and Leeds. In Manchester, access to justice for vulnerable people and opportunities for the legal profession were raised as the key issues. Leeds focused on the commercial case, which I always thought was quite strange given what we know about judicial review generally. And when we surveyed people around the time regionalisation was being developed, most thought that the main issues for access to justice were legal aid and specialist advice and awareness. Actually, only 30% thought that having a local administrative court would really make that much of a difference. So what do we find in terms of, these are the civil non-immigration judicial reviews by location of issue. And I'm happy to share these slides afterwards as well. Was that, yes, the proportion of claims being issued outside London started to increase up to about 35%. The research that had been done in the past actually suggested that about a third of all judicial review claims originated outside of London. So it was more a case of claims being determined at the appropriate location than any massive expansion in judicial review outside London. And what we've seen then has been a reduction down to about 24% of claims issued outside London in the lowest year. I mean, those statistics for 2021 are based on they're only 6 months, so they're not particularly telling, but there definitely has been an overall reduction in the number of claims issued in most regional centres, but most obviously Leeds and Manchester. So in this slide, what we have is Cardiff in orange and Birmingham in blue. You know, they are bumping along at a relatively similar level, although there has been a decrease, but you can see Leeds in the grey and Manchester in the yellow that there has been a notable reduction. 2020, as we've heard, has been a strange year, so perhaps we shouldn't take too much from that. But you can see fewer claims being issued in Manchester and Leeds in 2020 than were issued in Cardiff. But we have to remember Cardiff is responsible for the southwest of England as well as Wales. I'll just talk quickly through some continuing findings. Really, it continues to be the case, we think, that populations local to regional centres are accessing the public law system much in the same way as they were prior to regionalisation. There is more use of deputy judges outside of London. There is no evidence that regional firms are issuing a higher number of cases after regionalisation. And in fact, the number of claims being issued in the administrative court from solicitors based in Northern England has reduced. And we found that actually because of the nature of public funding, initially the regionalisation regime kind of entrenched specialisation because the public funding regime rewarded specialisation in particular areas, particularly things like prisons and police. And that's really what has, we think, impacted the North the most. So there's still a high number of GMC cases in Manchester. Other high areas initially were homelessness, community care, care standards, local government planning remain high, but the massive drop-off has been in prisons, parole and police. And you can see some of the statistics there, that these were, you know, around 60% of cases and now have gone down a lot. And what we found in our research was that this restrictions on legal aid for prisoners was one of the issues, and that there were firms who were specialising in prisons, police and parole who are no longer doing judicial review or who've closed down entirely, and that a lot of this was to do with the legal aid context and other reforms. In Manchester, overall, a lower proportion of claims decided in favour of a claimant than the admin court average. Still lots of police, prisons and parole, but important local hearings. 48% determined by deputy judges, one judge in particular, and particularly prominent counsel. Leeds, again, lower proportion of final substantive hearings decided in favour of claimant, slightly higher than Manchester, 54% determined by deputies. And you can see the impact that the reduction of police and prisons cases, that's why we see this massive kind of reduction in claims issued in the North. There are a range of challenges, and I'm going over time, so there's only one that I will refer back to. I think it's very interesting that we thought that perhaps regionalisation would lead to this clustering of lawyers and that would improve access to justice. And actually what we find is there are fewer cases now being issued, and that seems to be in part primarily because of the legal aid and reforms context. But there is a question of what does moving the administrative court online mean for regionalisation. It's really interesting what we've just heard about the importance actually of local justice and of cases being in person, because the prospects of moving online, what we found in our research was we were speaking to people based in Manchester, Sheffield and Leeds who practiced public law, but practiced really through the Royal Courts of Justice in London, now online.
Thank you, Sarah. That's fascinating. I wonder whether the regionalisation project would have had its support from the Ministry of Justice if we were online and dealing with cases in the hybrid way, because as you say, one of the prominent rationales for the regionalisation project was access to justice. If I can just ask you one question, and I appreciate you've done extreme research in this area, pre and after, but do you think regionalisation has worked?
I think it's worked differently in different locations. In Wales, because of the constitutional case and because of devolution, and we now have even more reforms to the civil procedure rules that relate specifically to Wales. I think it's really taken off. It really has worked. but that's in the context of devolution as well, and the increasing powers of the Senedd and the way that public law practitioners in Wales have picked up on that it has been a kind of constitutional success and a kind of access to justice success. In the Midlands, there, as well, I think that it's good for access to justice. It's good for the practitioners. I think that the concern for Northern England is, definitely in the sense of, you can see when you read as many cases as I do, that really important local issues are being determined in local court centres, and that really has symbolic importance. And for that alone, I think it's worked. But it has been undercut by other issues in access to justice and judicial review. And a lot of those are the kind of reforms that came in from around 2013 onwards. And in that sense, there are bigger issues about access to justice, but then there are also bigger issues to think about public law and think about public law beyond judicial review. So one of the other things we found is we had data from the Law Society, which showed the number of practitioners specialising in public law. We compared that to data from the Law Society now about the number of practitioners specialising in public law, and there are far, far more public lawyers about now than there were. But there is then this question mark around what exactly is it they're doing, because there are a lot fewer of them doing judicial review than it used to be the case. So I think, I suppose finally, just the UK Administrative Justice Institute gave evidence to IREL and said, I think we need a broader review of administrative justice, and actually what are all the different routes to redress for people, and how are they all working, and then how are they all working at a local or regional level rather than just judicial review.
Thank you very much. That's very insightful. Sarah, thank you very much again for attending our conference today. And as I did to Sir Julian, we virtually applaud your session. Thank you very much. And as before, you're more than welcome to stay for the rest of the afternoon if you wish. Okay, so we're now going to move to our second part of this afternoon, which is essentially a panel discussion on practice and procedure. And we're going to be starting our panel discussion about grounds. If I can invite Philip Robson to talk about grounds, and thereafter I'll come to Matthew Smith to update us on costs, and latterly Stanzi Bell to talk about updates on practice and procedure. All three individuals, as are the other individuals speaking this afternoon, are leaders in their fields and specialists in costs and administrative law, judicial review and planning. So as I said, I'll come to Philip first. Philip, what's been going on in the world of grounds? Has Wednesbury unreasonableness changed in its definition again, or are we where we were when we were taught it at university?
Hi Sam. Hello everybody. Remarkably, this is the first live virtual seminar I've done, so there's a slightly disconcerting shouting into the void feeling. I'm just going to assume that there are hundreds of active listeners and plough on nonetheless. It's a bit daunting when you get given grounds to talk about for 10 minutes, because I'm sure those of you that think back to your academic time will remember grounds taking up about 6 months of your administrative law course, and certainly a good amount of all of your daily practices. What I want to do is just focus on two cases which I thought have brought out two interesting points related to grounds, because in the broadest sense, in the sense of them being back to the GCHQ case of illegality, irrationality and procedural impropriety, of course, that doesn't change a great deal. What happens is they evolve and are applied to different scenarios. And one of the cases to which the irrationality ground was applied related to artificial intelligence, and whether or not the cost of making amendments to an artificial intelligence program would affect the rationality of deciding whether to or not to implement a solution to a problem. But we will get to that case after first, as a planner, obviously taking a diversion to a planning case which was Friends of the Earth and Heathrow Airport from last year in the Supreme Court. Now, why I thought this one was interesting is it's not perhaps what one might consider a direct evolution of what we understand as of the basic grounds for judicial review, but it's certainly one that provides some further clarity on what may form the basis of your judicial review. So what is the decision that is subject to challenge? Now, this was a case that related to the decision of the government to support a third runway at Heathrow Airport. And the Court of Appeal had initially decided that the Secretary of State had acted unlawfully because he'd failed to consider the United Nations Framework on Climate Change, which is known as the Paris Agreement, which I'm sure you'll all have been all be familiar with after the last month or so, and the focus on Glasgow. Whether or not the Glasgow Agreement takes on the same importance, we will wait and see. Some sceptics, certainly. But the focus of the challenge was what was meant by the term government policy. Now, of course, challenges to government policy are not new and are indeed one of the more frequent challenges that are brought in the High Court. So what is meant by government policy is obviously an important part of our practice. Now, the Court of Appeal had said that government policy, which was the phrase used within the Planning Act, were ordinary words which should be applied in their ordinary sense, and that the two ministerial statements which were made immediately before the signing of the Paris Agreement were such policy for the purposes of the Planning Act. Now, the statements were two statements by cabinet ministers to the House of Commons, one by Andrea Leadsom, remember her, who said, and I quote, "We believe we will need to take the step of enshrining the Paris goal of net zero emissions in UK law. The question is not whether, but how we do it. And there is an important set of questions to be answered before we do." And then 10 days later, Amber Rudd, who was at that time the Secretary of State for Energy and Climate Change, responded to an oral question in the House about enshrining the net zero emissions commitment of the Paris Climate Change Conference, and said, "The question is not whether we do it, but how we do it." So you have at this stage two very similar statements by two cabinet ministers to the House of Commons, which appears to state that what could amount to a policy is that the net zero emissions commitment in Paris was to be enshrined in law. Now, the Supreme Court disagreed with the Court of Appeal. The Court of Appeal said that amounted to policy, said that when you've got two cabinet ministers saying that the Paris Agreement will be enshrined in law, it's just figuring out how we're going to do it, that amounted to sufficiently amount to a government policy. The Supreme Court disagreed and said that the absolute minimum was a statement that was, and this is the direct quote from the judgment, a statement that was clear, unambiguous, and devoid of relevant qualification. The ministerial statements made in this case did not satisfy those criteria. Neither had referred to the temperature targets, and both left open the question of how the Paris Agreement goal of net zero emissions would be enshrined in UK law. The fact that the UK had ratified the Paris Agreement was not of itself a statement of government policy. At the point when the Airport National Policy Statement, that's the government policy dealing with the third runway at Heathrow, was designated, no carbon target had been specified, and there was no established domestic policy on climate change beyond what was already encapsulated in the Climate Change Act. So the courts there, the Supreme Court there, setting out what we need to look for when we're deciding what would amount to government policy, and that statements by ministers that may appear to be relatively clear in the House of Commons are not sufficient to amount to government policy. And the concern which the court raised was that if you broaden that definition too widely, you will end up with civil servants, lawyers, trawling Hansard, trawling speeches given by ministers for any hint of something which is not consistent with perhaps a published government policy as a traditionalist would understand it, and then seeking to mount a judicial review on the back of it. So the definition has now been tightened up, and we should all go to that judgment when looking to decide whether something which would push the boundary of what would amount to a government policy is something that could be subject to judicial review. The second case I wanted to deal with is the Secretary of State for Work and Pensions and Johnson in the Court of Appeal from last year. And this is the rationality case. So you may remember there was a number of cases brought about universal credit. And the point of universal credit is that it's, for those of you that don't know, is it's supposed to be a single welfare payment that's paid monthly in arrears to the beneficiary. And it is assessed by reference to a fixed monthly assessment period, which runs from the first date of entitlement and includes a standard allowance and amounts to reflect various different elements which are assessed. And then there are deductions made in respect of any earned or unearned income. It was meant to bring all of the various different benefits that existed previously under one roof. And of course, it's had a number of practical issues and legal issues as well. One of the issues was that the artificial intelligence system, which does a lot of these calculations when the data is input into it, was not able to take account of how the dates on which people are paid and the different ways in which the dates on which people are paid are given effect. So, for example, where people are not paid on the same or to avoid a non-working day, you can end up with a paycheck or two paychecks coming within the same period for the purpose of universal credit assessment, not within the same periods for the purpose of assessing their wages. But as a result, the universal credit bot thinks you've received two wages during this time, and therefore significantly reduces the amount of benefits they receive. And then the month after thinks that they've received no income, and therefore that again changes the amount of universal credit that they would receive in the subsequent month. The fancy name that's given for this, and I hope I've explained it well, is called the non-banking day salary shift. Probably not something that's going to immediately stick in your mind. Now, the argument that was run by the Secretary of State was that there is potentially a solution to this, which requires significant amendments to the artificial intelligence program that does the calculation. However, that is extraordinarily expensive and would take huge amounts of time and would take, and therefore wasn't worth implementing, irrespective of the fact that this bot was having significant effects on people's incomes. And the way that the claimant put it was that it was irrational to say that in those circumstances, amending the bot was too expensive to justify not doing it. And the judgment came for. The judgment came for. Many tens of thousands of people were likely to experience the same problem as the respondents, and it was unrealistic to expect employees in low-paid jobs to have the bargaining power to convince their employers to change the date when they were paid. No one had warned them that the date when they made the claim might affect how much their money they received, and no one had suggested they ought to submit their claims in the middle of the month. The threshold for establishing irrationality was very high, but not insuperable. This was one of those rare instances where the Secretary of State's refusal to put in place a solution to this very specific problem was so irrational that no reasonable Secretary of State would have struck the balance in that way. I just thought that was an interesting case because it was a decision to recognise a problem but refuse to do anything about it. And it was the refusal to do something which was the point on irrationality.
Philip. Philip, you mentioned before about artificial intelligence. Random question, but how do you think the use of artificial intelligence in government decision-making is going to change judicial review? Because I say that with some experience when it came to the Department of Education's kind of decision about, well, probably a long time ago now, about the GCSEs and A-level predictions and how they used an algorithm, and then they set it aside and then went back to the good old-fashioned way of asking the teacher what they thought that a student should get. But that's a good example, isn't it, of how...
Absolutely.
Do you think that's going to happen more? Or?
More increasingly, because of the reliance on AI to do what previously banks of civil servants used to do in assessing claims or in administering any particular process, AI will be used instead. Yeah. So the question will be, what are you challenging? Are you challenging the individual decision that's carried out by the bot? Or are you challenging the decision to use the AI system and the detail that's gone into establishing the framework through which it makes its decision?
Yeah.
I mean, the one thing that is definitely going to happen, and no doubt this will be your experience from your case, is it's going to mean a lot of reading.
Yeah, I found, instead of going through minutes of cabinet meetings and stuff and things like that, but rather going through programs and actually not knowing at all what it's all about, but asking a computer data programmer or a coder to kind of interpret what the variables are. And
well, if a case comes that way and we need to cross-examine a computer programmer, I'm just going to ask for a leader and you can deal with it, Sam.
Excellent. The answer I was looking for, obviously. Thank you, Philip. And I should say that Philip is the author of the Grounds chapter in Patterson and Karima, as is Stanzi, who is about to speak later on practice and procedure. But thank you, Philip.
Thanks, Sam.
Matthew, can I call upon you to give us a précis of updates in the world of costs, because costs and judicial review have quite an unusual relationship. And whenever someone mentions cost capping to me, I kind of tremble in fear, not knowing what it's all about. But can you update us in the world of costs and judicial review, please?
Well, I can. But in my view, there's quite a lot going on that goes far beyond judicial review. I'm going to mention 3 cases at the end. I'm going to go through 4 points. First of all, I'm going to deal with hourly rates. It's a simple point, but you need to know about them. Secondly, I'm going to echo what Sir Julian Knowles said at the outset about document management. I'm going to mention briefly electronic bills, and then I'm also finally going to mention 3 recent cases. The first point on guideline hourly rates is important because a lot of you, being local authority solicitors, will have occasions when you're entitled to claim your costs. And because of Eastwood, what you will do is you won't claim those costs on some internalized charge. Because of that authority, what you will do is you'll charge them as if you were a solicitor in private practice, charging a reasonable rate. And the courts naturally in those circumstances will measure that against the guideline hourly rates. They're easy to get. They've been in operation since October of this year, since they were refreshed. And you will have used them for years and years and years. Please don't get hung up on them. Please don't give them too much importance. Have a look at what other people claim against you, by and large, for the sort of claim that you are, or application that you are responding to, that you've perhaps got the costs of, and charge a commensurate rate. And you can explain why those rates exceed the guideline rates, because all you're doing is you're claiming the market rate. And the market rate might be above the guideline rates. For example, and this will horrify you, about 10 years ago, I once cornered a city solicitor and I said, "What's your hourly rate?" And he wouldn't tell me. He said, "We never use them. We always agree a fee." And I said, no, but if you had to, what would your hourly rate be? It was an American firm. He said $1,425 an hour. And that was 10 years ago. It shows how inapplicable the guideline rates can be, and the guideline rates aren't written for things like judicial review. So claim a rate that's commensurate with your market. Next, paper management. If any hearings are going to continue online, they're going to be costs hearings. So get used to keeping your files electronically, because when your file comes up for some sort of costs hearing, you don't want to have to add to the costs by all of a sudden scanning in all the papers, trying to organize a bundle. It's much easier if you've got into an electronic way of working paper-wise. It's far easier if you have a judge who has a preference for paper. It's far easier to print out sections of an electronic file than it is to take a huge paper file and start scanning it in. As a practical tip, on the 29th of this month, the 29th of November, 2 days ago, there was a revised guidance issued. All you need to type into Google is General Guidance on Electronic Court Bundles. Use that latest guidance dated the 29th of November 2021. If you take away only one point, that single point is that the page number of the PDF reader, the number that you can enter by punching into the screen, must match the internalized page number. If it's only out by one number, it's just irritating. The second most important thing is the document, all of it, not just parts of it, all of it must be optically character recognized. And if you're not used to doing this, get used to it, because you'll soon learn that there are cheap pieces of software. You don't have to use Adobe at hundreds of pounds a month. Buy one called PDF Exchange Editor. I've used dozens of these and I've thrown away most of them. And that one, it's about $60 and it works brilliantly. If you want the link for it, I can give you the link. It's got no connection with me. I'm not trying to sell it. But it's useful for example, if you get a bundle, it's not optically recognized. All you need to do, you must split it up, because all of these things crash if the bundles are over 1,000 pages. Split it up into 1,000-page chunks, optically character recognize it, recompile it, bookmark it, and then you've got your bundle for your costs hearing that you can use. Once you've bookmarked it, save time. Your indexing can be done at the push of a button. All of that is really important. If you're good at it and you go into a costs hearing, you might be paying. In fact, more frequently, you may well be paying. If your opponent is claiming a lot of costs for slow and clumsy document management, if you know what you're talking about, you should be able to get rid of a lot of those costs. The third element of what I was going to talk about, electronic billing. When you get a bill, on occasions, this might not last forever, there might be a move. The present thinking about electronic bills is that they are wonderful for interrogating information, but they are clumsy to use actually in an assessment of costs. And I know a lot of what you do will be summary assessment, but sometimes judges like even the summary schedules to be on some sort of spreadsheet. If you prepare a set of points of dispute, so far as that is concerned, bear in mind that the pro forma points of dispute precedent G was not written with electronic billing in mind. And a lot of people happily go on stating what their objections are, and then the judge says to them in the hearing, yes, but how do I know? I've got 3,000 entries on this spreadsheet. How do I know which of your entries your 25 objections relate to? The answer is, if you have an overarching objection, too much time on documents, too much time on internal reviews, too much time on internal communication, too much time on preparation of the applicant's witness statement, for example, state your objection and give it a key, give it a number, and then pick a spare column in the electronic bill. And each of those entries that you argue there's been too much time on a witness statement, you put that number in. Once you've done that, or a code, once you've done that, you can then filter it. And if you filter it, you can bring up each and every entry in the spreadsheet or bill that correlates to that objection. And you can say to the costs judge, we've objected to costs under a particular head, filter by this code, and you can look through them and you can just give one figure in relation to what might be 25 or 50 entries on the spreadsheet. Finally, on electronic billing, before I turn very briefly to the three cases, if you find anybody who is working a system whereby they can print out their bill at the end of the case, immediately let all your colleagues know, because there are people charging a week's worth of time simply for the preparation of a fairly straightforward electronic bill. I had one that was small by comparison. It was about 300 lines long, and somebody claimed 3 working days for preparing it. And the whole point of these was that you're supposed to be able to prepare them at the push of a button. Fourthly, and finally, the last heading of the brief 10 minutes that I wanted to discuss with you, 3 cases from this year that are probably going to come in useful. The first one is the useful one. The second 2 are just examples why you should never give up hope. But the first useful one is Barking and Redbridge University Hospitals NHS Trust against AKC. And the neutral citation for that is 2021 EWHC 2607 Queen's Bench. And I can give it you again if you missed it. Don't worry, I'll be available by email. The 2 points you need to remember from that case are: 1, if you get a bill in from somebody who you've been ordered to pay costs, the signature on the bill has to be legible. The second point is, if you've ever had any of these bills that simply say work done by a grade C, or work done by a solicitor, or work done by that nondescript entity, a litigation executive, you're entitled to go back to the people who drew that bill and say, on the strength of this authority, we are entitled to know who did what and when. So ask for who the fee earners were, and then you can look them up. You can see how long they've been doing the job. You can see if they've got any qualifications. And it's a case that lots of people who draw bills ought to be complying with already. The second case is Shahi and the Secretary of State for the Home Department, 2021, England and Wales Court of Appeal, Civ 1676. I said these second 2 cases were just so that you should never give up hope. This was somebody who got asylum support payments, and they were going to stop. So the applicant brought a judicial review claim just to tide him over until he could get credit, national credit. And he went and he made an application for interim relief. And the judge who granted interim relief did it simply for the balance of convenience. But 11 days later, the client got benefit. So there was no need then for the asylum support payments. So at that point, he withdrew his application for judicial review. And on withdrawing, the order for costs was no order. And he said, but I won. I got everything I wanted. I should have got the costs of my judicial review application. Court of Appeal dismissed the appeal. And the final case, CPRE Kent against the Secretary of State for Communities and Local Government, 2021 UKSC, simply confirming after a grumble, this was a costs case that went to the Supreme Court. And the one universal thing you'll see is if a costs case goes to the Supreme Court, they say costs is a procedure or our procedure. We don't deal with procedure. We shouldn't be troubled by this. But what they confirmed was that, generally speaking, claimants who are unsuccessful at the planning stage of either a judicial review or a planning statutory review, no matter how many of them there are, will usually, no matter how many defendants there are, respondents there are, the claimants who are unsuccessful will usually be liable for those defendants or interested parties' costs. That's the general principle. And the moral to take away from those 2 cases is that you will be the paying party quite frequently. Never, ever give up. Always look carefully at the facts. There's always an argument to be had. Never surrender the costs too readily. And that, I think, is more like 13 minutes than 10, but for that, my apologies.
Perfect. Thank you, Matthew. I hope everybody takes away those bullet points. I'm very grateful. I'm going to move then swiftly on to Stanzi, if I may, to give us a bit of an overview about practice and procedure. And I think there's been quite a few things happening, hasn't there, in terms of practice and procedure. So Stanzi, do you want to take us through them, please?
Yes, thank you very much, Sam. I'd be delighted to do that. And I think a lot of the points actually I was going to make have been fairly well travelled at this point by others. So what I've just posted in the chat box is a link to the Administrative Court Guide 2021. It's always interesting to me how many people haven't had the opportunity to review this excellent document. So if it's something you're not familiar with, I'd urge you to make use of that link and add it to your judicial review toolkit. It's a truly excellent resource, and it's designed both for lawyers and litigants in person, and it's often referred to in Court of Appeal and Supreme Court judgments dealing with the practice and procedure of judicial review. So well worth looking at that in your own time. In terms of the headline points for practice and procedure, well, a lot of the key points for practice and procedure relate really to electronic filing of bundles and virtual court hearings and the need for good document management. And those points have been very comprehensively explored by other speakers. I'll certainly be asking Matthew for his for the link to his bundle making tool in due course. So I'll move on then perhaps to some other key points in practice and procedure. Firstly, urgency. And the court has recently had occasion to restate the importance of really considering whether urgency is in fact required. And what an urgent case must demonstrate is firstly, the reasons for the urgency must be set out clearly on the application notice. Secondly, there must be a strict adherence to the duty of candour in terms of disclosing all relevant material. And this is particularly true in cases where an urgent application is being sought, because of course, there is limited notice to the defendant. So the claimant really does have a very serious obligation to put before the court everything which is material to the decision in issue. And there have been some severe sort of judicial reprimands where it's been felt by the court that simply hasn't been done. And finally, there should be compliance with procedural rules and practice directions and other obligations owed to the court, particularly because the nature of an urgent application is that perhaps it's not possible to give the notice that ought to be given, and so there ought to be good compliance in all other respects. The appellate courts have increasingly identified concerns about the need for appropriate procedural rigour in judicial review, and this really is encapsulated in several key procedural headings. Firstly, carefully considering who are in fact the proper parties to any claim. Secondly, rigorous compliance with the duty of candour, particularly, as I've mentioned, when making urgent applications. Thirdly, making applications at the earliest stage possible so that they're not left to the last minute. And that takes on particular significance in the age of COVID, where it might be necessary to apply for the court for an adjournment, for example, because of somebody being unwell. And finally, compliance with deadlines set by court directions, the CPR, all practice directions, and applying for relief from sanctions when documents are filed late. And I should mention also filing documents and authorities in hard copy and electronic form in the correct format, something which we've heard about and we know from this earlier this afternoon often is still causing great difficulty. The Court of Appeal, in an interesting postscript in the case of Dolan and Secretary of State for Health and Social Care, made an observation about the rolling approach to judicial review, which those who are frequent judicial review practitioners will know refers to a situation where fresh decisions which have arisen after the original challenge, and sometimes even after the first instance judgment, are sought to be challenged by way of amendment. So you seek to amend your pleadings in order to challenge a fresh decision arising out of earlier decisions. And the courts have reiterated that there's no hard and fast rule in terms of whether or not those applications should be allowed. But they've said it's usually better for all parties if judicial review proceedings are not treated as rolling or revolving. And that was stressed by the court in the case of Dolan to be particularly so in the present case, where the regulations in issue had in fact been amended. There's one other, I think, point of practice and procedure that's worth flagging, and that is the nature of academic claims. So the court will usually not hear a claim which has become academic, but they retain a discretion to do so. And the basis of that discretion is set out by Lord Slynn of Hadley in the Secretary of State for the Home Department ex parte Salem case. There's a discretion to hear disputes which have become academic, but the discretion has to be exercised with caution, and appeals which are academic between the parties shouldn't be heard unless there is a good reason in the public interest for doing so. And that good reason in the public interest is usually when a discrete point of statutory construction arises which doesn't involve detailed consideration of facts and where a large number of similar cases exist or are anticipated, so that the issue will most likely need to be resolved in the near future. And to give a sort of worked example of that in context, I was recently involved in a Court of Appeal case with Paul Tucker, Queen's Counsel, who's our head of chambers, acting for Liverpool City Council, where the issue was interpretation of green wedge policy, a planning policy. And in that case, the matter had been compromised between the parties in terms of the actual facts of what was proposed, but there was still a live issue as to whether or not there had been misinterpretation of the green wedge policy. And the court decided that they would entertain that challenge because whilst it was technically academic, the question of how one was to interpret that policy was a matter of public importance because there was still live applications to be determined by Liverpool, which would need to understand the correct approach to that policy, and there will be other authorities that might be similarly affected across the country because they had similar planning policies. And so it was important to give a definitive judgment on the interpretation of that policy. And the Dolan case also concerned the issue of whether or not an academic challenge should proceed. And in that case, the appellants were challenging regulations made in response to the COVID-19 pandemic, which sought to introduce what we've all commonly described as the lockdown. They submitted that the regulations imposed sweeping restrictions on civil liberties, which were unprecedented and unlawful. So the question really before the court was whether the Secretary of State had the virus to make regulations of that type. And even though the particular regulations in issue had been repealed, the court felt that that was still a live issue, whether or not the regulations could in fact be made under the same enabling power as a matter of law. And so that's another example of where a technically academic claim has proceeded in the public interest. Finally, one final point, Sam. I know people are probably itching to get into their breakout sessions. Coming up over the horizon, we obviously have the Judicial Review and Courts Bill 2021 to 22. I think it's on its second reading. It's worth, I think, a talk in its own right. There's obviously a lot that we could get into. So I don't know if you wish to treat that as an exciting trailer for perhaps our next online webinar. But it's certainly worth drawing to our listeners and viewers' attention because, of course, it makes key reforms to the law of judicial review and reforms implement, for example, recommendations to abolish so-called carte judicial reviews and providing an explicit statutory basis for courts to make suspended quashing orders and so delay the legal effect of their judgments. But the bill also makes provisions about prospective-only judicial remedies, which would partially or wholly treat historic illegal acts as though they were valid. And so lots of important procedural matters arising out of that bill. But I'm afraid due to the pressure of time, we'll have to possibly leave that point there.
Yeah, thank you very much, Stancy. And you're right, that requires some detailed consideration, perhaps on another day.